Hey everyone, Harry here to talk about the decision now in Maine to disqualify Trump from the ballot. That makes two states. Um, okay, a lot to be said here. First, the decision is by the Maine Secretary of State. That's what state law provides. She received several challenges, including a cluster from state senators saying basically, Trump doesn't meet the constitutional qualifications, same as if he were 34 years old, because having previously sworn an oath, he engaged in an insurrection. So he's not qualified now to run for president. Her opinion, that of the Secretary of State, is methodical, lawyerly. She's not a lawyer herself, actually, but she got a lot of legal help and very deliberate. It's a solid opinion as far as state law goes. In fact, in one respect, it's much stronger than the Colorado case. She really takes on this question that was pivotal for the Colorado trial court, which is whether the president is an officer within the meaning of Section 3 of the 14th Amendment, as he needs to be. If he's not an officer, then the provision doesn't apply to him or her, but for this to Trump. And the Secretary of State opinion here does more than Colorado did. Some very good legislative history, contemporaneous practice, etc. Makes a pretty strong argument for what common sense seems to provide anyway, and that is that the president is an officer. That's going to matter, as I'll explain in a bit. Otherwise, the reasoning is pretty similar, in some cases expressly similar, to what the Colorado Supreme Court did. She says, first, this is a self-executing provision. That's going to be one of the big contentions in the U.S. Supreme Court. But she takes the side of the conservative scholars and Judge Ludig and Larry Tribe, saying you don't need a separate independent criminal conviction or anything like that. It's just a constitutional provision. You interpret it, same as you interpret the other qualifications like 35 years old and natural born. And she says it was an insurrection that occurred on January 6th. And she goes through a definition of insurrection based on what an expert had to say. She says Trump suggests there must be more. There must be machine guns and a bunch of people. And she says even if there has to be that, it would be met here. But here's the definition. And then for engaged in, she calls that a closer call, but that has to do with his state of mind and the First Amendment. And she goes through that methodically as well and finds that it's satisfied. So it's a solid opinion under state law, and the people who are, including Trump comes right out of the box saying she's a partisan, which, by the way, she is. She's not just a Democratic office holder, but she previously did tweet to the effect of this was an insurrection. So if that's a reason under state law to recuse her, maybe that's what the courts will say. But it's a solid opinion, and she made the rounds explaining it to the different cable stations. And to me, she impressed. She's, calm, rational, lawyerly, evidence-based, etc. Okay, so that's the opinion, and it's fairly solid, as I say. Now, what happens to it? There's a lot of quick, breathless news saying now Maine has joined Colorado and holding he's not qualified. That's not exactly right. The process provided in Maine is you go from the Secretary of State to the Maine courts. It'll go to the Superior Court. And so, Maine hasn't spoken as a state any than Colorado had spoken as a state when just the trial court had issued an opinion, but it's well on its way. Okay. Now, I think the big lesson here is this redoubles the headache for the U.S. Supreme Court. because there's another case out there now, whatever happens to it. And even if it sort of goes away, it really brings home, it makes manifest what's been latent in the Colorado Supreme Court opinion, which is the real possibility that different states properly following their different state laws could come up with determinations that Trump's not on the ballot. And you could really have, now states are the ones who normally determine this. It wouldn't be, it would be funky, but not clearly a constitutional crisis if two said he wasn't foreign born and two said that he were foreign born, or, but here, if the court has to be now acutely aware that if it doesn't somehow definitively reverse Colorado's opinion, that is, in a way that really applies broadly to different states, we're really looking at the possibility of a patchwork situation where some states have Trump on the ballot, others don't. That's a mess. That's chaotic. Maybe the court, which is loath to actually, get in the middle and decide things, especially if it's going to be, 6-3, and there'll be contentious, politicized opinion making. Maybe they let that happen, but you got to think that their lookout is for some uniform federal solution. Now, what could that be? It could be a textual interpretation, as I said, for example, that the president isn't an officer. I do think that's harder to do now after the Maine opinion. It's pretty well done. It could be that the definition of insurrection is too loose, though that would invite certain states to repair it. They could quickly use the more muscular definition that the Supreme Court says is out there and kick them from the ballot, and there'd still be this problem. It could be that they say that it's not self-executing and it's up to the Congress and the Congress alone to decide. And the history of the application of Section 3 gives some support for that. And that would, I think, solve the problem for the court, because no way that both houses, and in particular the House of Representatives, controlled by Republicans, is going to vote him off the ballot. Now they'll own it though if they do that, and either way they might. So, but I think the real sort of impact of this decision is it increases the stakes for the court. They can't find just a sort of one off way to get rid of the Colorado case. They really need to find something that will apply across the board, unless they want to apply across the board a holding that he committed insurrection and he's not qualified and he's off the ballot. But that would be a revolution of another sort, and would bring the other set, the more violent Trumpy set, to the ramparts against the court. So they're really they already were in a tight spot, but now that Maine has ruled, they're in a tighter one. So to summarize, pretty good opinion under state law, especially on the question of is the president an officer. Doesn't mean Maine's finished yet. It still has to go through the courts, but really drives home to the Supreme Court of the United States the challenge of finding a solution that will prevent a patchwork, inconsistent application of the amendment to different states, and really puts them in a tough corner because they want very much not to be responsible for deciding the election, and if at all possible, not to be polarized and embittered and divided, etc. But that ups the stakes here quite a bit. So there you have it. Stay tuned for what happens in the Maine courts. In the meantime, because, and we talked about this earlier today, the Republican committee in Colorado petitioned the court. They're a party. So it seems to me, under the Colorado Supreme Court opinion, their stay now stays in effect until that petition has been disposed of. Everyone's waiting for Trump's petition and a very fast resolution of it. But, maybe the court takes up this one, or otherwise Trump is not under the same kind of time pressure. So that's a whole nother sort of side drama in what I think is really a singular, unprecedented case in many ways. So we'll see what happens in Maine, see who else joins the bandwagon, if any, and see what issues are served up to the Supreme Court to try to solve this mess without themselves being, completely put in an even worse position in the national view than they already are. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.